Good morning, everyone. Thank you so much for joining. We can go ahead and get started. My name is Danica Hobzet, and I am the volunteer coordinator with AIDS Legal Referral Panel. Today we have with us Rachel Kafele and Patricia Ribeiro with Oasis Legal Services. They're presenting on HIV positive asylum legal highlights. So first I'll do a brief introduction and I'll provide some information about my organization. Then I'll introduce today's presenters. We'll move into today's training and we will have time for questions at the end. So I would like to thank a couple of parties. I would like to thank the HIV Legal Services Fund of the American Bar Association HIV AIDS Impact Project. Their generous funds make it possible for us to bring you this MCLE today. I would also like to thank Oasis Legal Services for their partnership with this MCLE training. Just a few housekeeping items. This training is being recorded. You can submit questions to us two different ways, either through the chat function or the Q&A function, and we will have time to address those at the end. In order to receive CLE credit, you must complete our survey. I'll put the link to that survey in the chat. I will also send it out by email. And then lastly, after the webinar is over, it should automatically open up in your browser. Once you submit that, then I will send you the CLE certificate by email. All of our past virtual CLE trainings are available on our CLE Hero site. That URL is on the screen now. You can view past trainings on demand for CLE credit. And now just to provide you a brief introduction to my organization, AIDS Legal Referral Panel. We were founded in 1983 in response to the AIDS epidemic. At that time, our organization was just 4 attorneys drafting wills and durable powers of attorney for those who were dying of AIDS. Drafting those documents allowed these individuals to fulfill their wishes about healthcare and dispossession of assets. Over the years, the needs of our clients have changed and our organization has grown and changed as well. Since founding, we have handled over 80,000 different legal matters for our clients. We offer both direct services in-house with our staff attorneys, in addition to operating as a lawyer referral panel. We maintain a very large and diverse community of volunteer attorneys. Between our staff and our panel, we are able to help our clients with a wide variety of legal matters. Some of those areas include immigration, housing, and employment, but there are many more. Our goal in offering these trainings really is twofold. First, we do hope to increase the capacity of those serving individuals living with HIV or AIDS around the country. In addition, we do hope to recruit new talent to our panel to help us meet the needs of those living with HIV or AIDS in the San Francisco Bay Area. If you aren't currently a part of our panel, I really do hope you will consider joining. As an attorney on our panel, you play a critical role in allowing us to provide free and low-cost legal counseling and representation to our clients. We just ask that you accept 2 referrals a year, and you always have the option to pass on a referral if you can't take on a new client at that time. We conduct a thorough intake with each client so that we can make an informed referral to you based on your expertise and your availability. There are many benefits to joining our panel, but just to name a few, you have access to these free MCLE trainings. There are mentorship and training opportunities and networking opportunities with other panel attorneys and our board. If you're interested in joining, please don't hesitate to reach out to me directly. You can reach out by phone or by email, and our application can also be found online. I'll put my email in the chat so it's easy to grab. And now I'll take just a few minutes to introduce today's presenters. Rachel Kafele is Oasis Legal Services co-founder and legal program director. A Bay Area native, Rachel graduated from Wesleyan University with a BA in Latin American Studies and cum laude from NYU School of Law in 2010. After working as a public defender at the Miami Public Defender's Office after graduation, she transitioned to immigration law and began working with LGBTQ+ asylum seekers in 2013, helping queer and trans clients from all over the world find safety in the US. At Oasis, she heads the legal program in addition to representing clients in complex asylum cases. Patricia Ribeiro is a staff attorney with Oasis Legal Services. Patricia is a queer Brazilian immigrant. She grew up between Brasilia, Brazil, and the San Francisco Bay Area where she has resided for the past 15 years. She is a graduate of UC Hastings School of Law, and prior to law school, she worked within the immigrants' rights field as a community organizer and as a paralegal. She joined Oasis in the fall of 2021 and has been representing clients in complex asylum cases. And with that, I will turn things over to today's presenters. Thank you so much.
Thank you so much, Danica, and thank you everyone for joining us today. I'm Rachel Kafele, the Legal Program Director of Oasis Legal Services, and I'm joined by Patricia Ribeiro, our wonderful staff attorney. Today, we will be talking about HIV asylum cases and also some best practices when representing HIV-positive asylum seekers. Before we start, I wanted to give a brief introduction to the work and communities we represent at Oasis. We proudly offer quality legal services to LGBTQIA+ and HIV-positive immigrant communities with the goal of acknowledging, respecting, and honoring our clients' struggles and stories and experiences to foster empowerment and physical and emotional safety. We represent clients in affirmative asylum, residency, naturalization, VAWA, and family petition cases, as well as provide holistic case management and wraparound services. Since opening in 2017, we have served over 2,000 queer and trans and HIV-positive immigrants and have won asylum for over 500 clients. Today, we're going to start with a brief overview of some key points of asylum law, and then explore how an HIV diagnosis relates to and impacts the different elements of asylum through an exploration of 4 case hypotheticals, specifically focusing on past persecution, well-founded fear, other serious harm, the 1-year filing deadline, and credibility. And we will end by discussing some best practices for confidently representing HIV-positive asylum seekers. So to start with, there are 4 main elements that the asylum seeker needs to meet in order to win asylum. First, there needs to be a showing of harm that rises to the level of persecution, and Patricia will be talking more about the distinction between harm and persecution soon. Second, the harm needs to be on account of one of the 5 protected grounds, which is the 3rd element to meet. And finally, the persecution must be caused by the government or a non-governmental or private actor that the government is unwilling or unable to control. So to go back to the 2nd element, that's the element we usually call the nexus requirement. And the asylum seeker must show that the persecution they experience is connected to a protected aspect of their identity, either their race, religion, nationality, political opinion, or a particular social group. Because of the nexus requirement, it's possible to experience extreme harm in your country of origin, but not be able to qualify for asylum. The protected ground can be actual or imputed, meaning you can actually have the race or political opinion or belong to the religion, for example, or it can be imputed. So a good example of this is imputed political opinion or imputed membership in a particular social group. So for example, you happen to be walking by a march or protest that is happening and the police attack you because they believe you to be a protester. That would be an imputed political opinion. Or you are HIV positive and people in your community learn that and believe you are LGBTQ because they believe that only LGBTQ people get HIV. Inability or unwillingness of the government to control the non-governmental actor engaging in the persecution can be shown through a number of ways. So it can be shown through the actual failure to protect, perhaps shown by prior reports to the police that didn't go anywhere. It can be shown by the futility or danger of reporting, that it would, for example, that it would put you in more harm to report and out yourself as a member of the protected group. It can be shown by the government's failure to protect people similarly situated to you. You can also meet this prong by showing that there are discriminatory or other types of laws on the books that target members of your protected group, but you would also need to show that those laws are actually being enforced. For HIV asylum cases, the protected ground we work with the most is the particular social group, or PSG. So this outlines the current test of whether a PSG is cognizable under the law, and it has 3 prongs that all need to be met. So first, the characteristic in common must be immutable or fundamental. It's something that the person cannot change or should not be required to change. For example, HIV status or gender or sexual orientation. Second, the group must be socially distinct, which means the society in question perceives the group as a group and treats this group distinctly. Third, the group must be particular enough that you can tell who is in the group and who is not in the group. So there has to be the ability to draw lines around the group. The PSG test is pretty convoluted and somewhat unworkable, and has also been used by immigration judges, the BIA, and circuit courts to exclude bona fide asylum seekers from protection. In February 2021, the Biden administration released an executive order on asylum, and one of the promises was to promulgate new regulations which would address the circumstances in which a person should be considered a member of a particular social group. And the executive order said these new regulations would come out in 270 days. It's now been more than 365 days, and we are still waiting for these regulations. So this is an area where we desperately need more guidance to support asylum seekers. For HIV-related particular social groups, it's all going to come down to whether being HIV positive is socially distinct in the society in question. We know that being HIV positive is an immutable characteristic, and the group is particular enough to be able to draw in and out group boundaries. There's a blood test that can show whether someone is HIV positive or not. So our job is to show that in fact, there is in fact social distinction, and a particular social group, for example, of HIV positive men, for example, is recognized as a socially discrete class of persons in Mexico. So we would do this through country conditions research that we submit to the adjudicator, which could be newspaper articles or human rights reports, UN reports, reports done by other countries, asylum adjudicators, for example, to show that HIV positive people are perceived as a group in that society.
Good morning, everyone. So how to establish asylum. First, I'm going to give a quick overview of persecution. Although persecution is not specifically defined within the INA, the courts have held that a threat to life or freedom on account of race, nationality, religion, political opinion, or PSG is always persecution. Persecution is usually physical, but can also be emotional or psychological. Some examples are serious physical harm, coercive medical or psychological treatment, and severe discrimination. And it must also be motivated, as I mentioned earlier, by one of the protected grounds. It is important to note that US immigration courts have determined that inadequate medical treatment in one's home country does not amount to persecution for purposes of political asylum laws. So if you're able to show past persecution, then there is a rebuttable presumption of a well-founded fear of persecution. The presumption of well-founded fear can be rebutted by the government if a preponderance of evidence shows that there has been a fundamental change in circumstances, or that the applicant could reasonably relocate to another part of the country of origin. So for example, for changed circumstances, a person came to the US fleeing persecution because of their sexual orientation, but then suddenly there's a shift in public perception of LGBT people. Suddenly laws are enacted and to protect LGBT individuals and are actually enforced, and violence against LGBT people is greatly reduced. In that case, the government can say, well, the reason you fled is no longer applicable. It is now safe for you to return to your country of origin, for example. For reasonable relocation, the officer will say, well, the harm happened in city A and you can move to city B and be safe. And if they can show that you'd be safe elsewhere in the country, then there is no presumption of well-founded fear of future harm. But even where future harm has been rebutted, you can still be granted an asylum in the absence of well-founded fear of persecution. And there are two ways to a discretionary asylum grant. The first is a humanitarian asylum based on other serious harms. A person could be granted humanitarian asylum if there is a reasonable possibility that they may suffer some other serious harm upon returning to their home country. This harm does not have to be on account of a protected ground. In other words, there is no nexus requirement, but you must show past persecution. So first, you show that there was a past persecution, then you can use other serious harms, noting that this harm has to rise to the level of persecution. So for example, other serious harms can be if a person will not be able to receive HIV medication in their home country. The second humanitarian asylum this can be granted when a person has suffered severe past persecution. It's based on the severity of the past persecution. So for example, FGM, severe prolonged torture, rape has sometimes been held to be severe past persecution. But one severe beating, for example, probably won't qualify. So to qualify for humanitarian asylum due to severe past persecution, there must be compelling reasons why a person is unable to return to their home country, despite not having a reasonable fear of future persecution. A strong case for humanitarian asylum involves past persecution that caused severe harm and long-lasting effects. And this is considered on a case-by-case basis. So I'm going to briefly explain the one-year deadline, and then we'll talk about the exceptions. So the general rule for the one-year bar filing deadline is that an asylum seeker is expected to apply for asylum within 1 year after their last entry to the US. However, sometimes for various reasons, people are unable to apply for asylum within their first year. If this happens and someone is applying more than a year after their last entry, they have to affirmatively prove that they're subject to an exception to this bar. And there are two exceptions as noted on the slide, either extraordinary circumstances relating to the delay in filing the application within the first year, or changed circumstances, which materially affect the applicant's eligibility for asylum. And this is a two-step process. So first you establish the existence of either or both changed circumstances and extraordinary circumstance. And then you establish that the filing was effected within a reasonable time given those circumstances. And the rule of thumb is that a reasonable time is generally 6 months or less. The evidentiary standard is to the satisfaction of the adjudicator. It is not beyond a reasonable doubt or by clear and convincing evidence. So now let's look at each exception a little closely. Again, for extraordinary circumstances, it has to be directly related to the delay in filing the asylum application. It's also important to note that the extraordinary circumstance does not need to relate to the claimed past or future persecution. And there are many exceptions, as you can see on the slide. Lawful status, for example, the person had or has DACA or has a valid student visa. Legal disability, which is usually when the individual was not yet at the age of majority or 18 years old. And effective assistant of counsel, where there are some serious procedural hurdles and other circumstances. There's also serious illness or mental or physical disability. And for example, that would be PTSD or depression that prevented an applicant from applying for asylum sooner. At Oasis, we focus on the serious illness or mental or physical disability. Many of our clients have suffered severe trauma, both in their country of origin and other countries, and potentially in the US as well. This can mean physical harm, sexual abuse, forced imprisonment, many other scenarios that cause them severe trauma. This trauma can manifest as PTSD. So if an individual is experiencing PTSD when they come to the US and it is an ongoing situation, they are likely to qualify for extraordinary circumstance exception from the 1-year filing deadline. Other mental health situations, such as severe depression, panic disorder, severe anxiety, could potentially qualify as well. There's less case law on mental conditions outside of PTSD, but we certainly have had a lot of successes in those cases as well. Applicants must file within a reasonable time of overcoming the extraordinary circumstance that prevented them from filing. Again, a reasonable time is generally considered 6 months. So for example, the person is able to open up and talk with their medical or mental health provider about their past trauma for the first time ever. That would be extraordinary circumstance. Things to know: if they are referred to a legal service provider, typically the clock starts when they have their first appointment. But a referral to a legal service provider can also be seen as starting the reasonable time clock. Change circumstances. That's when there are changes in the applicant's home country or in the applicant's circumstances that materially affect their eligibility to apply for asylum. So for example, a new law passed in their home country, or the person is diagnosed with HIV, or they started gender affirming treatment, things that now make it more dangerous for them to return to their home country. Once the change circumstances happens, the applicant again generally has 6 months to file for asylum. Again, the issue is when the clock starts. So for an HIV diagnosis, for example, does the clock start on the infection date or on the diagnosis date? Well, the rule is that if the applicant can establish that they had not become aware of the change circumstance until after it occurred, such delayed awareness shall be taken into account in determining what constitutes reasonable period. So the best practice in these situations is really helping your client trust you so that they can disclose details that you'll need to help overcome the 1-year filing deadline. If you are going for a mental or physical disability, you really need an evaluation from a medical provider. So a psychological evaluation and or evidence or testimony regarding the individual circumstance. So for example, a letter from their doctor stating that now they have been diagnosed with HIV, when they were diagnosed, what kind of care they're undergoing, that all can be helpful, as well as knowing what medications they're taking, what kind of treatment is necessary. Those things can also be helpful for an asylum case. So now we're going to do our first round of case hypotheticals, and I'm going to introduce them both. I will unpack Fernando, and Rachel will address William. So Fernando is an asylum seeker from Brazil. He was diagnosed with HIV in Brazil in 2017. While in Brazil, he faced employment discrimination, and he was ultimately fired from his job because he's HIV positive. He also experienced physical abuse from his partner and neighbors for being HIV positive, and he had difficulty consistently accessing HIV medication. Fernando entered the US in September of 2021, and he applied for asylum in February of 2022. William is a gay asylum seeker from Honduras. In Honduras, he experienced sexual abuse where the abuser insulted him for being gay. He experienced physical abuse from his parents for being feminine. He entered the US in December 2005. He was diagnosed with HIV in the United States in 2017, and he submitted his asylum application in June 2021. So we're going to do a quick poll here. Do you think that Fernando qualifies for asylum? And can William get over the 1-year bar? And I'll give you a minute to answer.
The poll is up now, and we're getting some answers in. We'll give folks just a little bit longer. And Patricia and Rachel, just letting you know we're doing well on time.
Okay, thank you.
Wait just a little longer. All right, go ahead and share the breakdown and answers that we had. So for question 1, the majority of respondents answered yes. And for question 2, there was a little bit of an even breakdown between the first and the third answers.
Okay, thank you. Thank you, everyone. So for Fernando, the answer is yes, he could probably qualify for asylum. And we're going to see where his HIV status comes into play, what elements. So where does HIV status come into play in Fernando's past persecution? So here, Fernando can likely show past persecution on account of a PSG. And the first question, what's the possible PSG for Fernando? And some options are men from Brazil who are HIV positive, or HIV positive Brazilian men, or Brazilian HIV positive men, and any variation of that. What harm did he experience because of this PSG? So we know he faced employment discrimination and that he was fired from his job because he is HIV positive. So again, past persecution requires showing that serious harm took place. It's likely that this discrimination alone won't be enough to rise to the level of persecution, but because Fernando also suffered physical abuse, we can use this discrimination as cumulative instances of harm. So the federal courts, as well as the BIA, have held that cumulative instances of harm considered in totality may constitute persecution on account of a protected characteristic, so long as the discrete instances of harm were each inflicted on account of the protected characteristics. And here we know that Fernando was discriminated against and fired from his job because he is HIV positive. Also, as Rachel mentioned earlier, for an HIV-related PSG, it's all going to come down to whether society is socially distinct. To whether it is socially distinct in that society or country, and if people in that country view HIV positive or people with HIV as a distinct social group. So here, the fact that Fernando experienced employment discrimination can help show that his PSG is socially distinct in Brazil, because you can argue that people have an urge or tendency to discriminate against him because he is HIV positive. We also know that Fernando experienced physical harm from his partner and neighbors because he is HIV positive. This likely rises to the level of persecution because he suffered physical harm on account of a PSG, men from Brazil who are HIV positive. We also know that Fernando was unable to consistently access HIV medication. While this was difficult for him and he might want to argue it as harm, unfortunately, we can't, because inadequate medical treatment is generally not considered persecution. HIV plus asylum applicants will have difficulty securing asylum status on this basis alone. Now, regarding nexus, the third question, how do we show nexus? As Rachel mentioned, establishing nexus involves answering the question why. So you must show why the persecution was directed at the applicant. There's direct evidence. What did the persecutor say to them while committing the harm? And also indirect evidence. So you'll ask questions related to timing or other signs or signals indicating that the harm might have been done because of a protected ground. So for example, did they beat you after they found out that you are HIV positive? So here we'd explore the job discrimination. Did people say anything to him? What exactly did they say? Or for indirect evidence, did the discrimination start only after they learned Fernando was HIV positive? And I'm assuming, but we'll ask, that he was fired only after they learned that he is HIV positive. Regarding the physical abuse he suffered from his partner and neighbors, What physical abuse did he experience? We'll want to explore that. Did they say anything to him while they were physically abusing him? Or for indirect evidence, did the physical abuse only start once they learned that Fernando is HIV positive? Did it get worse or more frequent after they learned of his status? And lastly, Fernando was unable to consistently access HIV medication, as we know. But there is no nexus here, and it could potentially go to other serious harm, which I'll address in a bit. So where does HIV status come into play in Fernando's well-founded fear of future harm? Here, based on Fernando's past persecution, he is probably going to get the rebuttable presumption of well-founded fear. Again, it can be rebutted if a preponderance of the evidence shows that there has been a fundamental change in circumstances, or that he could reasonably relocate to another part of Brazil. So as Rachel mentioned also, we will submit country condition documents such as State Department country records, human rights reports, articles showing that folks who are HIV positive are treated how HIV positive folks are treated in Brazil. And for reasonableness of relocation, you can show the culture of animus towards people who are HIV positive in Brazil. Also, if medical confidentiality is not very strong in Brazil, and people find out he is HIV positive, he can be imputed to be gay as well. So here, for example, we know that Fernando's neighbors found out that he is HIV positive, and we'd explore that with him to find out exactly how that happened. But that makes it so people can assume he is gay. So now there's a heightened risk, and you can argue that there will be more animus towards gay men who are HIV positive, and also a heightened severity of the harm, because it's now on account of both him being HIV positive and because people assume he's gay. So where does HIV status come into play in Fernando's other serious harm? This is a future-looking analysis. And for other serious harm, remember that first we must establish past persecution. So we know Fernando suffered past persecution. He experienced physical abuse from both his partner and neighbors because of his HIV status, and he possibly experienced cumulative harm of employment discrimination and being fired from his job because of his status. Other serious harms must also rise to the level of persecution. So here we can argue that his difficulty consistently accessing HIV medication is another serious harm, as it is a threat to his life. And remembering that there is no nexus requirement for other serious harm. So in Fernando's case, this argument will likely be unnecessary because he should get the rebuttable presumption of well-founded fear, as we discussed earlier, but you should still make this argument in the alternative.
Okay, so now let's unpack and explore William's case some more to explore how his HIV diagnosis is going to affect his asylum claim. So the first question is, how does William's HIV diagnosis impact his well-founded fear? Second and related question, does William get a rebuttable presumption of a well-founded fear if he returns to Honduras? And third, finally, can we argue other serious harm even though he was diagnosed with HIV in the United States? So we know from the hypo that William suffered physical and sexual abuse for being gay in Honduras. That kind of harm is going to rise the level of persecution, and it's on account of his membership in the particular social group of gay men from Honduras. So yes, it's very likely he is going to get a rebuttable presumption of a future fear of persecution if he has to return to his home country. We would also want to argue that his well-founded fear is strengthened by his HIV diagnosis in the United States. Although William cannot testify that he experienced harm in Honduras because of being HIV positive, like Fernando could, he can testify about how being HIV positive will increase the risk of harm he faces. So for example, there might be more, or there will be more animus against him if he's gay and HIV positive. And also his sexual orientation and HIV positive status is now easily discoverable if, for example, Honduras does not have good health or medical confidentiality, and people in his community learn that he is HIV positive and then make the assumption that he is gay. So even if he's trying to hide his sexual orientation to protect himself, the disclosure of his HIV positive status could cause harm to him because of people's assumptions that he's gay. Another argument to make is that the harm William faces will be more severe. Perhaps he would have feared discrimination for being gay if he returned to Honduras, but now with his HIV diagnosis, he feels very vulnerable to both discrimination and also physical harm and abuse. Finally, his HIV status can go towards the reasonableness of relocation. So perhaps in big cities, there is more tolerance of LGBTQ plus people, but there is countrywide animus against HIV positive people. So living in a big city would not protect me, and relocation for William would not be reasonable. In order to back up William's testimony about how his HIV diagnosis increases his well-founded fear, like Patricia said, and like we've been mentioning, it's really important to have strong country conditions that show the danger to HIV positive people in the client's home country. And then finally, for the last question, yes, we would be able to argue other serious harm in William's case as well, if we can show that he would not have access to HIV medication in Honduras, which would negatively affect his health. And this is because William did experience past persecution. It doesn't matter that the past persecution was based on his sexual orientation and not his HIV status. The past persecution does not need to be related to his HIV status in order to get this other serious harm analysis. So this was a question that got some different responses in the poll about whether William can overcome the one-year filing deadline issue. So we know that he does have a one-year filing deadline issue because he entered in 2005 and his asylum application was not filed until 2021. So first question, could his HIV diagnosis be a changed circumstance for William? And in this case, the answer is most likely no. So his HIV diagnosis would not be a way for him, although it probably could be considered a changed circumstance, because it materially affects his asylum claim. He would not qualify most likely for the changed circumstance exception to the one-year filing deadline, because it would be a stretch to argue that William filed his asylum case within a reasonable time of his HIV diagnosis. So yes, his HIV diagnosis makes his asylum claim stronger. It materially affects his well-founded fear, but he filed 4 years after his HIV diagnosis. And as Patricia explained earlier, reasonable time is usually considered in months, not years. So usually the rule of thumb is 6 months. So he applied 3.5 years after those 6 months elapsed. But could William's HIV diagnosis bolster his one-year filing argument in another way? And yes, and this is an argument we frequently use in our cases at Oasis for our HIV positive clients who have a one-year filing issue and have not filed within 6 months of their HIV diagnosis. So for William, we would want to get him connected to a mental health professional who could do an evaluation to see if the trauma he experienced in his home country has led to a diagnosis of PTSD or some other trauma-related disorder. So the evaluation would have to give the opinion that within William's first year in the United States, within that year of 2005 to 2006, William was suffering from a serious mental or physical disability. And we would use this evaluation to show that it was the extraordinary circumstance of this mental disability that caused the delay to William's asylum application. We also need to show that his PTSD continued beyond the first year in his country because he didn't file until 2021. We would want to use the HIV diagnosis to show that his mental health was exacerbated by the HIV diagnosis. So we would explain that William was unable to apply for asylum in the years between 2017 and when he filed his asylum application in 2021 because of the emotional and perhaps physical effects of being diagnosed with HIV. So the delay from 2005 to 2017 to 2021 was reasonable. We have two more case hypotheticals to illustrate some more points about HIV asylum. So first we have Gerardo's case. Gerardo is a gay asylum seeker from Mexico. In Mexico, he was always in the closet. He was never out to anyone about his sexual orientation. And the harm he suffered in Mexico was he was called homophobic slurs in school. So he experienced some bullying. Gerardo entered the United States in 2010. And in December 2021, he was diagnosed with HIV and Kaposi sarcoma. He has applied for asylum in July 2022. We also have Paul, who's a gay asylum seeker from the Philippines. In the Philippines, he experienced physical abuse as a child from his parents for being gay. And as an adult, he experienced domestic violence from his romantic partner and also discrimination at work. Paul has entered the United States a total of 5 times using his tourist visa. And 2 months after his last entry into the United States, he was diagnosed with HIV. He's now coming to you within his first year after that last entry to see if he is eligible for asylum. All right. We have more polls.
I'll go ahead and launch the next poll. All right. It should be up on the screen now.
Okay, so the first question is, can Gerardo get asylum even though he didn't apply for asylum within 6 months of his HIV diagnosis? And the second question is, does Paul need to use his HIV diagnosis as a changed circumstance for purposes of the 1-year filing deadline?
Great, thank you. We're getting some responses in. I'll leave it up for a little bit longer. And we're still doing well in time. A few more responses are still coming in. All right, I'll go ahead and share the results. So the majority answered yes for each question, but there were some no's.
Great. So we're going to start with analyzing Gerardo's case. So we know that from the hypothetical that Gerardo was in the closet in Mexico and the harm he experienced was bullying in school. So the bullying by itself is not going to rise to the level of persecution. So Gerardo will most likely not get the rebuttable presumption that he will face a well-founded fear if he returns to Mexico. Therefore, it's going to be his burden to show that he has a 1 in 10 chance of being harmed. And the 1 in 10 is, or 10%, is kind of how courts talk about the risk that you need to show that harm will happen to you if you return to your home country in asylum cases. So Gerardo's HIV diagnosis, however, strengthens his well-founded fear claim in the same way that it strengthened William's. It increases his risk of harm. There's going to be more animus, as well as an increased awareness in society about his membership in the particular social group of being HIV positive and also gay, since perhaps people might impute that to him because he is HIV positive. And you would need to show that there is a lack of confidentiality in Mexico around HIV status. You can also argue that there is now a heightened severity of harm. He won't only face bullying or discrimination, but is also at risk of physical abuse because of the HIV diagnosis. And then finally, if you can show that animus towards HIV positive people happens countrywide, you have met your burden about reasonableness of relocation. So again, to answer question 2, you're going to want to use country conditions. You're going to want to research what it's like in Gerardo's case for both gay men in Mexico and also HIV positive men in Mexico in order to corroborate his testimony that he's going to face harm because of his membership in that social group. So to address the 1-year filing deadline, how can we use Gerardo's HIV diagnosis to get over the 1-year filing deadline? An extraordinary circumstances argument will probably be difficult for Gerardo based on what we know, because we might not be able, or the mental health professional might not be able to diagnose him with PTSD or another trauma-related diagnosis, because what he experienced in Mexico might not rise to that level. But we might want to still get him evaluated because we always want to explore all the possible arguments. It does seem like Gerardo's HIV diagnosis could be a changed circumstance. And for that analysis, we would need to figure out whether his HIV diagnosis is considered a material change or not. The Ninth Circuit case about changed circumstances is Vahora v. Holder, which is a 2011 case. In Vahora, the petitioner left India because of general religious persecution towards members of his religion. He did not apply for asylum within his first year in the United States, and some years after he arrives, the religious persecution gets worse, and there begins to be religious riots, and some members of his family are attacked. The court found that this increased risk towards Vahora did count as a material change in his asylum case, and therefore he was eligible for an exception to the 1-year filing deadline, and also therefore eligible for asylum. So the Vahora case is important because there was an argument that when Vahora first arrived in the United States, he had enough well-founded fear to qualify for asylum since there was already religious persecution happening. But the court decision shows that the analysis isn't between whether you didn't have a case before and then after the changed circumstance, you now have an asylum case, but instead the analysis is whether the case is materially affected, which can mean whether the well-founded fear has been heightened or increased. So for Gerardo, he could, he perhaps had an asylum case before he was diagnosed with HIV because he is gay, and we know there's persecution against gay people in Mexico. But his HIV diagnosis made or strengthened his well-founded fear. It would be a material change that affects his asylum claim. So if we can show through country conditions that the severity of harm and the risk of harm to him is now heightened, he should be able to qualify for a change in circumstances. But as the last question addresses, we still need to show that Gerardo filed within a reasonable time. He was diagnosed in December 2021 with HIV and applied for asylum in July 2022. So the question is whether that lapse between December and July, so about 7 or 8 months, is reasonable. And like we've said, the standard is usually 6 months or less, but you would still want to make this argument that 7 or 8 months is reasonable. We know from the hypothetical that Gerardo was diagnosed with Kaposi sarcoma at the same time that he was diagnosed with HIV, and that's a form of cancer that can affect people with HIV and AIDS and be very severe. So with that diagnosis, we would want to explore, was Gerardo in the hospital for any amount of time? What kind of medical care was he receiving? How did his time in the hospital or the medical care or how he felt physically, how did that affect his physical and emotional ability to meet with a lawyer and to prepare an asylum case? So one could imagine that his ability to prepare an asylum case while he was struggling with Kaposi sarcoma was probably very limited, and he didn't really have any capability to focus on anything but his health. So we would use that to show that the delay from December to July is reasonable, taking in all the circumstances and factors. So to show this, we would want to use medical records and letters from doctors to show what Gerardo was going through during that time.
So where does Paul's HIV status come into play in his asylum case? So here, Paul is applying for asylum within his first year since his last entry. But the first question, how does Paul's 5 entries to the US impact his case? Well, it's going to impact both his well-founded fear and his credibility. Because it's going to be a difficult case to make that Paul has a well-founded fear of returning to the Philippines because he entered the US 5 times and returned to the Philippines after 4 of these entries. So the asylum officer will think, well, if you're so scared of returning to the Philippines, why did you return all those times before? And this leads to his credibility. Officers may think that Paul is not credible because he's claiming he's scared of returning to a country that he voluntarily returned to 4 times prior. So does his recent HIV diagnosis change any of that analysis? And the answer is yes, definitely. Paul was also diagnosed with HIV while here in the US, much like Gerardo and William. So he never suffered harm or persecution based on his HIV status back in the Philippines. So he won't have a rebuttable presumption of well-founded fear on his PSG of being an HIV positive gay man from the Philippines. But his HIV diagnosis does impact his well-founded fear because now, in addition to being gay, he is also HIV positive. Again, we'll have to present country conditions to show how his new PSG, HIV gay men from the Philippines, are treated in the Philippines. This is especially important because Paul will not have personal testimony of what it's like to be an HIV positive person in his home country. So how does his HIV diagnosis strengthen his asylum case? Because of his changed circumstance, he has been diagnosed with HIV. He now faces a heightened risk of suffering more animus. Also, his risk of the severity of the harm is heightened because in addition to being gay, he also has HIV. It can also affect the reasonableness of relocation, depending on the culture of animus towards people with HIV in the Philippines. And you'll show that again with country conditions. So here again, you can also make an argument in the alternative for humanitarian asylum, other serious harm. You'll argue that Paul suffered past persecution. We know he experienced physical abuse as a child from his parents for being gay, and cumulatively, he experienced discrimination at work. You should also explore the DV he experienced from his partner to see if there's a nexus there. So establishing the past persecution, you can use a possible lack of access to medication and treatment for HIV in the Philippines. And again, you'll need country condition documents to support this claim since Paul will not have personal experience with this.
Wonderful. So now that we have a complete and total understanding of how HIV positive folks can qualify for asylum, and I'm joking about that, we want to turn to some best practices when working with HIV positive clients. So first, it's extremely important to maintain client confidentiality. As lawyers, we know that we have an ethical duty to keep our clients' information confidential, and that includes our client's HIV status. But in addition to our ethical duties as attorneys, there's also several layers of legal protections that guard a client's right to keep their HIV status confidential. So laws relating to HIV privacy and confidentiality in California can be found in the California Civil Code, the Health and Safety Code, the California Constitution, under tort law, and also in California, there is a Confidential Medical Information Act, CMIA. Federally, there is still a right to privacy under the US Constitution, And there's also the Health Insurance Portability and Accountability Act that we're probably all familiar with, which is shortened to HIPAA. So it's extremely important to maintain confidentiality. And the question is, how do we do that? So first, it's important to explain our duty to our clients to maintain their confidentiality. So from the outset of the case, you want to explain and reassure a client that you are not going to disclose their HIV status to anyone without their consent. So it might seem like you shouldn't have to tell your client that you're going to be informing the immigration judge or the asylum office of the client's HIV status, because it would seem like, of course, they would want me to do that. It strengthens their asylum case. It increases their chances of getting asylum, but you still need to establish with your client that they want you to reveal that information to the immigration adjudicators. You also want to talk about other people that might learn and get the client's permission for that. You also want to communicate with your client about who they are comfortable sharing their HIV status with. So perhaps they come to the appointments with their partner, and you assume that, of course, their partner would know whether they're HIV positive or not. You cannot make that assumption, and you cannot reveal anything about your client's HIV status to anyone they come to appointments with, anyone in their family, romantic partners, etc. You also need to keep client information and documents secure. That includes their case file, any medical records that you get as part of the case, any digital or electronic records that you keep. You also want to make sure that you aren't referring to your client's HIV status in written communication with them. So you don't want to send a letter to their house, for example, saying, I need your HIV diagnosis state or other records if you haven't already gotten their consent to put that in writing and send it to their house. And finally, you don't want to share your client's HIV status to anyone without their express and written permission. So at Oasis, this is something we get and explain to clients when we get their permission in writing when starting their case. And we explain all the people who we think it's important to reveal this information to, but ultimately it's the client's decision about that.
So it's also important to educate ourselves, familiarize yourself with HIV prevention tools and medical care and treatment available to folks with HIV here in the US, especially because a lot of the clients who are recent immigrants to the US don't know of these resources yet. But also familiarizing yourself with these tools in the client's home country. Understand the difference between being HIV positive and having AIDS. AIDS stands for Acquired Immune Deficiency Syndrome. It's sometimes referred to as late stage HIV or advanced HIV disease. It's an umbrella term for illnesses that occur due to untreated HIV infection for several years, by which point the immune system is severely damaged and unable to fight off infections. So, as most of you know, every person who develops AIDS has HIV, but not every person who has HIV will develop AIDS. Ultimately, HIV is a virus that attacks the immune system, and AIDS is a term that can only be used when HIV has caused severe damage to the immune system. Once you have HIV, the virus stays in your body for life. There's no cure for HIV, but medicine can help you stay healthy and understand what it means to be undetectable. HIV medication lowers or even stops your chances of spreading the virus to other people. When your viral load is undetectable, or you can no longer detect the virus in your body, you can't pass HIV to your partners. Listen to your client about how HIV affects their life and how it doesn't. It's important not to make assumptions. Remember that your client may not know what it's like to be HIV positive in their home country, and it may be triggering or re-traumatizing to ask them to investigate country conditions and treatment options. But on the flip side, clients may only want to focus on the fear of accessing HIV medication in their home country to avoid talking about past trauma. So as their legal representative, you will have to balance those two because both are important. You'll need to work with the client and gain their trust so that they can start talking to you about their past traumas.
In addition to confidentiality, educating ourselves, it's also important to connect a client to resources. And why is that? So the biggest thing is that a client may not be able to focus on their immigration case because of their worry or fear over their connection to HIV treatment. So for example, a client may have recently arrived in the United States and not have connected to medical care yet. And they're stressed about that and aren't going to be able to really work with you on their asylum case until that's been completed and that connection has made. Or perhaps they're not feeling physically well because they don't have good medical care. A client also may be recently diagnosed and you're trying to work with them quickly to get their asylum case filed within that reasonable time period, but they don't like their medical care, don't feel that it's very affirming, and that's being a distraction to them in their asylum case as well. So one of the resources that we gave out in conjunction with this webinar is our Northern California HIV/AIDS resource guide. There's a link to a Google Drive. It was also attached to the email. We also have it in English and we have it in English, Spanish, and Portuguese. And it has resources divided by county that can be shared with clients to get affirming HIV care. So it's important to help your client to inquire, make sure that they're well connected and they're receiving treatment that feels affirming to them.
And finally, a few tips on being a good provider. Number one is following your client and make sure to do things with consent. So listening to what your client says and then doing what they ask you to do. If your client, for example, tells you their gender identity is female or a woman, you need to start thinking about them as female or women. Otherwise, it'll be much more difficult for you to remember to use the correct pronouns or to remember to describe them correctly in their application or their declaration. Similarly, giving your client choice and respect in that decision. So you may ask the client, what name they'd like to use, and they can say, oh, my legal name is P, for example. When in reality, what you're asking is what they want you to use. And so making it clear that it doesn't matter what their legal name is when you're having a conversation. It might matter for legal documentation, but when you're just having a conversation with your client in the office or other people in their life who might be present in the case, it's important to do what they want. Following that choice really shows respect. So respecting their humanity, treating them the way you'd like to be treated. You really need empathy. So really empathizing with the pain and trauma your client has experienced and understanding that these folks have experienced harm and severe trauma, but they are not broken. So focus on where they are now, how we're going to help them achieve their goals as their legal representative. Lastly, practice cultural humility. Understand that people are coming to you with unique perspectives, wisdom, cultures, and that we are learning in our relationship with them. Please never express that this is hard for you, that this is difficult to understand, or that it's hard to understand their gender identity or use the right pronouns, for example, or that it's otherwise somehow a burden to represent them. They have come to you as their representative, and it's really important to show that you are open to learning from them, to benefiting from your relationship with them, and learning from what they have to show you. And remember, Google is our friend. So if we don't understand or know something, try and look it up.
And then we just had one more slide. We wanted to make sure folks have our email addresses for questions. We also have a legal resources portal through our website where we can share the country conditions we use when representing our LGBTQ+ and HIV positive clients. So we have a lot of country conditions to support HIV positive folks from Mexico, from the Central America, from Brazil, from Colombia. So please reach out We are always happy to share what we have. And then finally, if you know of someone who you think might be eligible for asylum, we do free consultations and try to take however many cases we can. You can email us, call or text us, or submit a consultation request through our website.
Great, thank you so much. Thank you both for this presentation. This was great. So we do have one question from the audience, which actually everyone can take a look at by clicking on the Q&A function, which is in the bottom of the Zoom toolbar or the top. I can go ahead and read it out loud, and then we will have our presenters answer. So the question reads, I have a client from El Salvador who has a pending appeal at the Ninth Circuit. He has recently been diagnosed with HIV. I'm not finding good country conditions on persecution based on HIV status. Most abuse focuses on sexual orientation, which is what is already on appeal, but not HIV status. Do you recommend any experts or other options to show WFF of being persecuted on account of his status? Apologies for not knowing that acronym.
Yeah, so that's a really good question. We do have some country conditions on, to support HIV positive people from El Salvador. So I would encourage you to reach out through our legal resources portal, and I can share them with you. I don't know of any expert off the top of my head who could specifically testify about the harm that comes to HIV people in El Salvador. Another idea I have is, I don't know if this person did experience past persecution when they were in El Salvador, but you might have a new argument that they would face other serious harm if they return because of the lack of access to HIV treatment. And I have heard, medical confidentiality laws are not very strong in El Salvador. Clients personally have told us that people learn that you're HIV positive there. There's not a lot of confidentiality for protected medical information. Clients have expressed difficulty in getting access to HIV treatment. So I think exploring all of that would be important as well. But we're happy to share the resources that we have.
Great, thanks for the question. So it looks like that's our only question today. If you do have any more, please don't hesitate. You can reach out to Rachel and Patricia directly, or you can always reach out to me and I'll connect you with them. But I think that takes care of everything for today. Thanks. One other question just came through the chat. Oh, could you put the link for the portal in the chat, please? Mm-hmm. Yes, I can do that. Do you have that on hand, Rachel? And
I can type it in right now.
Perfect, thanks. And while we're doing that, feel free to submit any other questions either directly in the chat or through the Q&A function. Perfect.
I think someone might have raised their hand, but then it disappeared.
Let's take a look. Yeah, I'm not seeing that on the attendee list. I'm sorry if I'm missing you. Definitely reach out by email if there's a question that didn't get answered. All right. Great. Thank you again to everyone for joining. That concludes today's presentation. Thank you.
Thank you, everyone.
Thank you, everyone.